Welcome to the Jersey Justice Podcast, featuring your hosts, attorneys Gerald Clark and Mark Morris.
Justice, I wanted to read, you've written some dissents in cases, and dissents are basically where the justice doesn't agree with the majority, and you can vote to dissent, or you can, I guess, write a dissent, and then you write an opinion as to why you disagree. And have you had, you've written a number of dissents, have some of those dissents actually been used in the future, in later cases, years later, and essentially become a majority opinion yet in another decision?
Yes.
Like, why would a justice write a dissent? Why is it just sour grapes to say, oh, I lost and you're wrong and here's why, or is there a reason for it beyond that?
I think a number of reasons. I think number one, the public is entitled to know where you stand. So if you're going to dissent, to express your views, so the public and the bar have an understanding of where you stood on the issue. You also may be writing for some future court to see the wisdom of the position that you held. The first opinion that I ever wrote on the court, the first opinion I ever wrote was a dissent, and I was alone. And I don't know, 14 or 15 years later, the principles that I had advanced in that particular opinion became the majority view. So there's something to be said about longevity. If you just stick around long enough, you're able to advance the positions. So that happened on like a number of occasions. There was one opinion that I wrote. It's the case of statutory interpretation. I wrote the dissent, and 2 months later, the legislature basically overruled the majority, adopted my dissent, and put it into the statute, found that my interpretation was the true expression of what the legislature intended.
So, when I opened up today, I said, hopefully I don't screw this up, and I might be about to screw it up in the sense that I might put people to sleep if I start reading law, but I do want to read part of your dissent in a case. It was called, I believe it was In Re Brady from 2020, you wrote this, and it's, your dissent's a few pages. I'll try to read it quicker or skip sections, but you say, today's majority decision is a sad epilogue to Judge Carlia Brady's 7-year nightmare journey through the criminal justice system and the judiciary disciplinary process. 7 years ago, Judge Brady was the quintessential American success story, a Filipino-American immigrant who became an accomplished lawyer and rose from the ranks of the bar to become a Superior Court judge. Just several months after her judicial appointment, her career, her reputation, her health, her life would be in ruins, the victim of overzealous Woodbridge Township police officers who filed criminal charges that could not be sustained in court. Those dismissed criminal charges and the current judicial disciplinary charges stem from a tumultuous 36-hour period in Judge Brady's life. During that period, while reporting to the police the theft of her car, she learned that her live-in boyfriend, the father of her unborn child, the man with whom she had planned a future, was a potentially dangerous criminal and wanted for the robbery of a drugstore. In a state of shock, with her reality shattered and her trust betrayed, fatigued by 24-hour sleepless hours and stressed about her pregnancy, Judge Brady should have been the object of at least a modicum of police solicitude. Instead, she became the target of a hapless police investigation designed to make the case that she was harboring a criminal. Without getting guidance from the prosecutor's office and in a reckless rush to judgment, Woodbridge Township police officers arrested Judge Brady on the unsustainable charge of harboring a fugitive, and did so without returning her earlier telephone calls or listening to 2 voicemails she left with a police officer, one notifying him of her boyfriend's presence in Woodbridge. Officers then withheld their knowledge of the potentially exculpatory voicemails from a Superior Court judge, perhaps misleading that judge into issuing a criminal complaint. The filing of that complaint triggered a misguided criminal prosecution on evidence so thin and lacking in substance that the appellate division affirmed the dismissal of one charge and the trial court, on motion by the state, dismissed the 2 remaining charges. During the near 5-year prosecution, Judge Brady was suspended from her judicial duties. Judge Brady then exited from the criminal justice system and entered into the judicial disciplinary process. The Advisory Committee on Judicial Conduct held hearings and issued a one-sided presentment against Judge Brady. In doing so, the committee affirmed the doubtful credibility of the Woodbridge Township police officers, drew every adverse inference against Judge Brady, accepted between dueling expert reports the ones that disadvantaged Judge Brady, and then recommended to this court, meaning your court, the Supreme Court, that Judge Brady be removed from office, a recommendation rejected by every justice but one sitting on this case. From my review of the record, Judge Brady did not harbor a fugitive or obstruct a police investigation, nor did her conduct demean the judiciary. Judge Brady's conduct should not be viewed from the sterile 2020 perspective of hindsight, but rather from that of a vulnerable human being, fatigued and frightened in the grip of overwhelming stress, who, in the moment, made decisions that, even if flawed, do not rise to a level that warrants discipline. Had the police returned Judge Brady's phone calls, there is no reason to doubt that she would have responded truthfully to any questions presented to her about the location of her boyfriend. I do not find justified the post-mortem criticism of Judge Brady that she should be disciplined for not leaving more information on a voicemail that the police recklessly failed to retrieve, and for not acting as the perfect informant during the tumultuous hours at issue. The committee and the majority, it says the tumultuous hours at issue, and for not calling the police in the presence of a potentially violent criminal, which are things that the committee and majority faulted her for. Although justices must be held to high standards of conduct in their private lives, they too are subject to the harsh vicissitudes of life. Judges can be deceived in their personal relationships. Judges can suffer psychological stress and trauma. And even judges are not immune from the abuses of the criminal justice system. By the way, I found that section fascinating. I had it highlighted. In the end, I view Judge Brady as a victim, more deserving of an apology than a suspension. During the pendency of the criminal and judicial disciplinary proceedings, the period for her reappointment came and went, ending Judge Brady's judicial career. Because I do not believe that the charges against Judge Brady have been sustained by clear and convincing evidence, the imposition of discipline is not justified. I therefore respectfully dissent. That is like a powerful dissent. I know a bit about that story. Can you tell us kind of about that? What went into that thought process? And we also talked about power and judges and the separation of power and bad power. I mean, that seems like a situation where there were some overzealous police. You know, I don't know if you know, what are your, can you comment on that one there?
Well, that seems to have said it all.
Yeah. Yeah.
So, I think,
I mean, it sounds like she got railroaded.
yeah, I felt that she was targeted by the certain members of the Woodbridge Police Department. And although I have not reread the Brady case in quite some time, I do recall one particular fact, and that is the responsible investigating attorney, while surveilling her home, literally had the Code of Criminal Justice and was like flipping through the book to figure out like what he could charge her with if the boyfriend happened to come back. It was sort of a shoestring, haphazard, reckless, and sort of unforgiving type of investigation of a person who was the Superior Court judge, but who is very vulnerable, and you don't shed your humanity when you put robes on. You know, judges are held to the highest standard and should be held to the highest standard. But in this particular case, I felt that the way Carlia Brady had been treated within the criminal justice system, forget about the disciplinary system, was a total miscarriage. And the fact is, after many years of having these criminal charges hanging over her head, all of them were ultimately dismissed. And she had been offered all sorts of deals, I think including pretrial intervention, and she had turned all of them down. And at the end of the day, the state did not have the evidence to actually proceed with the prosecution and wound up dismissing the charges, and then became the judicial disciplinary process. So I just want to say one thing. I obviously disagreed with the Advisory Committee on Judicial Conduct in this case, but I want to acknowledge that the people who serve on that committee, despite the criticism I might have had in this case, are of the highest quality and caliber and integrity, and I respect them all, which made it particularly difficult for me to not only dissent in this case, but part of my criticism was fairly harsh. But it's important for everyone to know that the people who serve on the advisory committee are really the tippy top, and we're very fortunate to have them deciding these cases of judicial discipline.
And I'm sure it's also the same with the Woodbridge Police. I mean, I never agree with throwing the baby out with the bathwater. Maybe the officers had a bad day, or maybe it's just a couple bad apples or something. It's not it's not like the whole police department is somehow bad or anything.
I totally agree. Look, in private practice, I represented Woodbridge police officers. So this is true of every police department. The great majority are hardworking, dedicated, trustworthy, ethical, and then there are a few that obviously are not temperamentally or otherwise equipped. That's true of almost every profession. That is not singular to police officers. And then there's the element of, even if police officers are acting in good faith, there is the quality of human error, which is present in any undertaking, a police investigation or like a judicial undertaking.
Any thoughts? So, go ahead.
No, that's justice. I mean, we could go through. We talked about, what was it, 130 something dissenting opinions, and obviously you're passionate about a lot of issues, and you've got a brilliant legal mind. So you don't ever strike me as one to just sit on the sidelines and let something go by if you disagree with it. So to take the time, and what Jerry just read, it shows kind of your passion for the stances that you do take. But kind of, can you tell us what you're doing now? Obviously, your mandatory retirement came up.
Let me ask, if you don't mind, about the Anthony Ways case a little bit.
Yeah, sure.
Let me ask you about that. So one other case before we, and Mark, I apologize for cutting you
it's
off
all right.
on that one. Can you tell us a little bit about the Anthony Ways case? This, as I understand it, it's something that dealt with a drug deal had gone bad in Camden. I think one of the people that was looking to buy drugs, the alleged guy that was going to sell the drugs, went into an alley and then came back to the alley supposedly with the drugs, but instead he came back with a .44 Magnum. The driver of the car got scared, hit the gas, sped away, and then got shot. And Anthony Ways was charged with the crime, convicted, I believe, of homicide. And as I understand it, somehow you took a second look at the evidence, and it dealt something with post-conviction relief and witnesses that came up after the time. And I think it was something where your clerks had kind of dug into it a little more. And can you tell us a little bit about that case, what you remember from that?
Yeah. So that was my second year on the court. And I explained to you earlier that they're oral presentations. So that was not one of the petitions that was assigned to me. So a member of the court was making an oral presentation, and during the oral presentation, something seemed wrong to me about, obviously, the way the case was decided, and I was concerned that we might be denying this cert. So what you're permitted to do, not that it happens often, you can say, like, let's hold this case, and I'm going to review it. I'm going to give it a really close look. So I in this particular case, it was an eyewitness identification, which was really questionable. And then there was a pretty substantial, like, alibi. The question was whether or not this shooting occurred at one bar or another bar. Okay, there was like a Wally's bar and I forget the name of the other bar. But they were like a block apart. So I went back to my chambers and I explained the situation to my law clerks and then assigned one of them to get all of the transcripts of the trial and of the post-conviction relief hearings. And that person happened to be Jenny Brooke Condon, who is now a professor of constitutional law at Seton Hall. And then after we reviewed it, we thought that there was a probability, based upon newly discovered evidence, which had it been presented to the jury, the outcome would have been different. It wasn't an easy sell because of findings by the PCR court, but they were sufficient. And to give all credit to the court, I made the presentation and the court granted certification. And then the case was argued, and ultimately we granted post-conviction relief, reversed the murder conviction. And at that point, I sort of lose sight of it. And I'll just give you a little of the background of the case as I recall it.
I believe he was freed.
He was.
Yeah.
Yeah, but I didn't know that at the time. I would later learn. I'm gonna give you the postscript on it in a second. So Anthony Ways was a young man, and he dabbled in the drug business. There wasn't any question about that. So the two young men had traveled into Camden from either Haddon Heights or Haddonfield looking for drugs. The driver of the car was being directed by the passenger, and then someone came to the window of the car, accepted money, was supposed to have gone back into an alleyway, and then came back with a gun and said, give me your money. The driver, hit the accelerator. The person shot into the car and wound up killing the passenger. The car sped off, crashed, took the victim to the hospital, died. Then the driver of the car was taken back to the scene, and he was taken to a bar that had no alleyway. Like 1 block up, there was a bar with an alleyway. And at that time, simultaneous, unknown to the police, a fellow goes into the bar and says, this fellow King just fired into a car. So he's telling the bartender and some other people there things that would match up with the shooting occurring somewhere other than where the victim said it occurred. Most of that came out during the course of the trial. And look, from my review of the evidence, there was sufficient reasonable doubt for a jury to find him not guilty. But, we leave these matters to the jury. And judges typically are not the ones to second guess a jury. But there was a motion for post-conviction relief that unfortunately took 5 years to hear. So he's sitting in jail and there are a number of people who are now coming forth with evidence that seems to be supportive of the exoneration of Anthony Ways. And this guy King, who is brought into court and says, no, it wasn't Anthony Ways. No one asked him who the shooter was then. And part of the additional discovery is that King admitted to having the same type of gun that was used in the murder, and was attempting to sell that gun that very evening. Right? And
it works good because I killed someone
Yeah,
last
yeah.
night.
Shoots
and
straight.
it had like one bullet missing from the chamber. And one of the person who testified at the post-conviction relief said, "Yes, is there like a body on that gun?" The guy said, well, yes. Well, I don't want that gun. A lot of it came out but there was enough additional evidence that would have supported it, and it led to my reconfiguring also the law of motions based on newly discovered evidence, because typically you can't use as an argument that if the evidence was merely contradictory or impeaching. And what I said, but on the other hand, one of the other factors is if the evidence would probably have made a difference, then that's a factor. Now, the point I made in the opinion, which I haven't read in a while, is that it can't be merely impeaching or contradictory if it would have made a difference. Okay, then it's not merely, okay? So for instance, there's a difference if you have like one alibi witness or three alibi witnesses, or one identification witness or three identification witnesses. The jury may not believe one identification witness. They may believe three identification witnesses. May not believe one alibi witnesses. So like merely, so the other term is, I said, merely impeaching, contradictory, or repetitive, whatever it was. It's not repetitive if it's going to make a difference.
Right.
So we rejiggered that. So you decide a case, and you don't know what the postscript is, like, where the person's going on with his life. So this is what happens, and I'm going to give you the long postscript. I'm at a state bar convention. I'm going back to my room, and a person named Charles Ray approaches me, who I've never met before. He had been waiting for me in a lobby and said, like, my cousin is Anthony Ways. This was probably like in 2019. And I went to law school, and I read your opinion. I recognized that was my cousin, and that made a real difference in my life. And I wanted to meet with you, and I wanted to put together a program where I put my cousin with you on the same panel, because my cousin had the murder charges dismissed. He went on having like a fabulous career. He's the head of a charter school.
Wow.
All these community civic activities. And as he's talking to me, people are gathering. People are around me, and he's getting me to pledge to do this program. And I agreed to do this program, and then I ultimately did the program, meeting Anthony Ways, and then hearing from him, which was very interesting to hear the perspective of the defendant, because he was telling everyone in this audience that at every point I thought I was going to be cleared. I'd be cleared by the jury. Oh, that didn't work. Oh, the appellate division will. That didn't happen. I petitioned the Supreme Court. Denied. PCR court. I have a hearing. Denied. Still have hope. I lose before the appellate division. And now there's this last shot before the Supreme Court.
Wow.
And on a PCR, the chance of getting that granted is really at the outer limits. That's so. It was one of those cases where you're saying where you can make a difference. The case resonated with me. I dug into it, and that's what happened.
It's all because of a kid who worked the night shift at the press and came home at 6 a.m. with ink in his ears because he was a hard worker. I mean, you very easily could have been like, it's Friday. I'm getting out of here. Yeah, denied. Let's go. But instead, you use that same work ethic and that concern about justice. And God, look at the change you made in someone's life. That's amazing. That's an amazing story.
No, it really is.
So there's one other one I'm going to tell you about because it resonates. And then I don't want to take any much more of
Yeah.
your time up. It was a case of Alexander Branch, and it had to do with an eyewitness identification. And we felt that the manner in which the identification process had occurred and some hearsay evidence deprived him of fair trial. So we reversed the conviction. Okay, the case is done. Years later, I am now sitting on a panel at the 25th anniversary of this local NAACP branch. And I speak, and there's an audience, and at some point, a man in the audience raises his hand and says, I just want to say something. I was like wrongly convicted. My case was reversed by the Supreme Court. And I just want to say we need more resources in the prison for paralegals and that type of stuff. So at the very end, some people are coming up to me and thanking me for appearing. And then this gentleman appears. And he shakes my hand. He says, I'm really happy that you came here to speak. And I said, can you tell me a little bit about your case? And he tells me a little bit about his case. And I say, what's your name? And he says, my name's Alexander Branch. I said, I wrote the opinion reversing your conviction.
Oh, wow.
Wow. That's awesome.
Yeah.
That's fascinating. You talk about making a difference at every level, It really is fascinating. So what are you doing now? I started to kind of get into that. You don't strike me as a guy that's just going to be sitting on a lake,
Playing a lot of golf.
twiddling his thumbs, playing a ton of golf.
No. So I'm the chair of the appellate section at Lowenstein Sandler. I went there to join my good friend, Krista Perino, who was the Attorney General of the state, counseled the Governor Christie, and I'm doing regular legal work. I'm doing like briefs, petitions. I successfully handled, although I can't appear in court on a second PCR, a 1986 conviction, racial profiling.
Wow.
I was able to manage to get that dismissed because the person was facing deportation in another state. So it's pretty varied. I've represented physicians, hospitals, and all sorts of different things.
It's great.
But I mentioned this one mediation that I've handled, which is really. But what has been really surprising to me, typically, a judge or justice goes out and is handling mediations and arbitrations, and I've handled one monster mediation and still handling it, but not mediations and arbitrations, and that I would look forward to doing. So I think I would actually be pretty good.
And what types of mediations? Because when I think about that, we do personal injury. We think about there's an insurance company typically, and we think the case is worth this. Insurance company thinks it's worth that, and then we'll oftentimes go to mediation. You were talking about school desegregation, more complex things. What kind of mediations are?
It could be anything. It could be major complex cases. I've handled personal injury cases. I've handled law against discrimination cases in private practice. It could be super complicated multi-litigation cases, commercial litigations. There could be personal injury cases.
That's awesome. Lowenstein Sandler's an awesome firm. I used to when my kids were younger, I would coach a lot of youth sports, basketball and baseball. And I always look at the schedule and I'd say, okay, we got this team coming up. That's going to be an easy game. Oh, this one's going to be hard. And when we file our cases on behalf of plaintiffs and we get an answer in and we know it's Lowenstein Sandler, we say, oh God, this is going to be a hard one here. This ain't going to be an easy game. So, for all those big insurance companies, and it's a great firm, and so that's all.
Yeah.
Anyone have anything else? Or?
No, thank you for the invitation. It's been great chatting with both of you.
Yeah, and thank you, Justice. We really appreciate you taking the time. I was saying before, we're a little starstruck having you come in, but really appreciate you taking the time.
Well, thank you.
And super fortunate to have you here. And just people should know, and I thank you for the changes that you've made in society with these opinions. We just talked about a couple of them, but I could go on and on how you've made things better for regular people in New Jersey with, there's so many different decisions, whether it's getting civil justice, when someone gets in a car wreck and, can't feed their families, and having trouble making ends meet, and enabling them to get the fair civil justice in court. There's so many different cases, and with the helping to nudge society along on equality in marriage and stuff. We thank you for all that stuff. I mean, people should know out there that this the young 23-year-old working at the overnight shift at the press and refused to just go with the grain and do what he was told, and wanted to make a real difference, has made a real impact in so many people's lives, including Anthony Ways, Branch, and countless others. So I thank you for that and your service.
Thank you. Greatly appreciate that.
All right, Justice Albin, thank you. That's a wrap.
Okay.